Good morning. Are you Wesley Antoine? And Mr. Antoine is here for sentencing on probation, a deferred probation for aggravated assault, family violence, and that was a 10-year deferred probation that he was given back November 14th of 2023. Entered pleas of true. It looked in the motion to revoke unadjudicated probation. I've received an updated pre-sentence report. This was an open plea to the court. Is that correct?
Yes, Your Honor. The court had previously, when we were here before, advised the court, that he received 4 months on that new case in Louisiana, but it does involve the same victim, Ms. Red, as his case here.
Mm-hmm.
We had discussed 6, and the court did not feel comfortable with that, so we just decided to go over to you.
Okay. All right. So that's what, and I wanted to remind myself, I had a notation on this about that new offense. So the new offense was in Louisiana, and it was domestic abuse, battery, also by strangulation, correct?
Correct.
Against the same victim. Lewis, you may proceed.
Judge, in this situation, in all my conversations with Mr. Antoine here, a lot of his issues come back to his mental health problems. And at the time, I believe he was not really open about getting the help that he needed with these issues. And once he got on probation, of course, those issues took over where he became in a very unstable situation. He admitted that he was homeless for a period of time there, which why he went back to Louisiana. All his family is there, where he has some sort of support system. And I believe he even talked about that he thought someone was trying to kill him here, which goes to the mental health issues and things that he was dealing with and had, especially during that time. His support system is still there in Louisiana, not including the alleged victim that was on the...
Not alleged victim.
I know he played to the judge, but he does not have any type of family support system here within Jefferson County. So, but I think since he will continue to have issues if he don't take care of any. I don't see, just from my communication with him, what I've seen, any substance abuse issues, but mainly it's just been the mental health side of getting that treatment in place that's needed. I think if that's taken care of first, then of course I think especially the technical violations, he will be able to handle. The new law violation, he did plead guilty to it. He did serve his time on that case. As well, he has been in custody here since this revocation. It's not like he's been at home. He has been being punished or serving time during this time here, Judge. We are asking that he is allowed to be evaluated for his mental health caseload, whether through SAFE or some other vehicle that probation may have that would help him get a grip on that, and that would, of course, help him get some stability for getting into the benefit.
So, do you have anything? I mean, I have your updated report. Is there anything else that you wanted to add that's not in that report?
No.
So I'm looking back, Mr. Antoine, at that original pre-sentence report when we put you on probation the first time. That was an agreed probation. That at this point seems it was a 5/5 probation. Is that correct? Am I looking at that correct? Is that?
Deferred for 10, Judge.
So maybe at sentencing that got changed. I'm looking at that old pre-sentence report, and that confused me somewhat because to make sure, I thought this was deferred. The motion was filed as a deferred, but I want to go back and double check because the cover page of the old pre-sentence report, no, it's a judgment of deferred.
That's what the order says. I think
That was just a mistake. Either I changed it or it was a mistake on the page. Okay. So on that original pre-sentence report, and the orders that went along with that, I mean, this is a first-degree felony. So on that deferred probation, it specifically ordered all the things. to be placed on the specialized mental health caseload, to get an evaluation and get any type of help and treatment that is available. You were ordered to do those things. And in fact, what you pled to on this motion, true, is that you didn't get the evaluation completed, and so you never were able to get services, and that was your choice. Everything was given to you. You had all the opportunities in the world to get whatever help you needed so that you could be successful. But the fact that you're on probation, I mean, the allegations in this underlying case is that you had a cane and that you just beat the crap out of Miss Red with that cane while she's on the ground. And then you get out and you get around her again and you strangle her. I mean, it's just beyond me. That's where what you would do. I mean, it sounds like you go to Louisiana, if you have support, that's great. But to go back and do that to her without permission, you weren't working, you didn't have your mental health, you didn't do your community service, you didn't do the batterers intervention prevention program, which probably would have taught you how to not beat on and attack and put your hands on. Enter your pleas of true to counts 1 through 11 freely and voluntarily. I'm going to find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault on a family victim. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I believe the initial was
Deadly weapon.
yes. I am going to make the finding that there was a deadly weapon in that initial case. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Good luck to you, sir. Sign that, and then you can go back with the bailiff.